Alright, did you guys miss me? Alright, this is Diesel We the People News one more time. Alright, this video is without prejudice and or without recourse. I am not waiving any of my rights, people. Alright, none whatsoever. I'm not an attorney, so anything I say or do is just my opinion. It is not legal advice, so don't take it as such. Why am I not giving legal advice? Because I'm not a licensed attorney. Or a bar member anyway. There's no such thing as a licensed attorney, but I'm not a bar member. Okay? I believe in justice, not crookedness. Alright, this is from Fake News Network. Alright? And a couple of videos back, we talked about a guy named Josh kind of fighting a traffic ticket. And I also brought up that, you know, he kind of broke probation or a parole or something like that. I can't remember exactly what it was. Due to he was at a friend's or family's house that actually had a fire poker for their fireplace. Oh my goodness, the crime of the century. Thank God for them cops out there. Whew, that was a major crime, so gee Louise. And heaven forbid if kids actually play baseball with their baseball bat. Oh my goodness. Crime of the century has been taken care of. Alright. So this is actually kind of a hearing. Federal bracelet monitor and a state monitor, right? He's got both of them on there. And what it did is cause conflict between the two jurisdictions. And so they're kind of going in there saying, hey, like, this is a problem, y'all. And of course, the state's going to have to go in there and just argue stupid crap. I mean, it's uncalled for. This, man, don't get me in line about some of this stuff that these states do. You know what I mean? Trying to broaden it out a little bit so you get a better picture, I guess. But I really need to get another SIM card for this other phone. Just, it is what it is. Alright, let's just... Oh, if you want to see the whole video, go to Fake News Network and actually watch the whole thing. And the arguments between both of them, even though this shouldn't be an argument, this is just plain out stupid, is what it is. Just plain out stupid.
Release conditions here, and to maintain those conditions here. The second thing is, ultimately, it's possible that the federal government does plead this case out, or that the defendant does get released from house arrest. Conceivably, his attorney in the federal system is going to file a similar release bail modification motion in federal court, and the judge may be more amenable to releasing or lowering bail in that case, at which point the only thing holding the defendant here will be what the state court has already found to be the appropriate level of release and monitoring, which is house arrest here. And so while right now the defendant does have two bracelets, that doesn't mean it's always going to be two bracelets, and that doesn't always mean that the state case and the federal case are going to resolve harmoniously with each other. And we have an obligation in this case, in front of this court, to make sure that the defendant that the victims and the community at large are protected from this defendant.
Understood. What about an order that he's only released from this house arrest so long as he remains on house arrest in the federal case, and that if for any reason that is removed, that the order is already a standing order that he must immediately report and be placed on house arrest in this case?
Your Honor, I think that ultimately that's not an unreasonable position for the court to take. The state believes that its argument about what this court, not Your Honor, but what Judge Villani and Judge Bell have found in the valid determinations of bail, and so modification is not necessary because we've already had a determination of what is the appropriate level of release. However, if the court has decided that it is going to make a modification, I think that would be the most appropriate, I suppose, resolution if the court decided that that was what it was going to do. The state would oppose that generally because I believe that Valdez-Jimenez has been determined. We have an obligation to maintain that prior order in the absence of full-blown reconsideration of bail. But I understand the court's position on that.
Okay, all right. The court finds that, first of all, there has been a change in circumstances, and although I obviously have utmost respect for all of the work that's been done in this case in front of both Judge Villani and Judge Bell, and the utmost respect for their decisions and rulings, I do believe that him being put on monitoring in the federal case is a change in circumstances that has prompted an appropriate re-review of the Valdez-Jimenez and prior bail sentencing. I also believe that this concern that there are conflicting requirements or at least procedures and policies with regard to the federal house arrest and the state house arrest is ripe for consideration now. I do not think that the accused needs to first be arrested and in order to make it right. I think we can clearly see what the potential issue is, and that potential issue could result in weeks or months of incarceration of the defendant, even though he hasn't done, technically anything wrong, other than by trying to comply with one house arrest, he is unable to do so without violating another house arrest. So I do find that concern is ripe for review. And all that having been said, I believe that the double house arrest is not appropriate, that for the reasons I just stated, it sets the defendant up to ultimately be arrested, and that it's not only that, but as far as it doesn't enhance the protection of the community or any of the parties concerned whose safety is of concern in this case, that being on one or the other sufficiently protects. And substantial proof of that is that he was on one, and that was determined to be sufficient. So at this time, my order is going to be that he's released from the house arrest in the state case, but only so long as he remains on house arrest on its current terms with no changes in the federal case. If that changes for any reason, there's a standing order as part of this order that he has 24 hours to report to Nevada house arrest program to be placed back on house arrest under its current conditions. Is there any clarification needed?
Just that I was being yelled at by Martina Bauhaus yesterday, Your Honor. It's EMP. It's EMP. It's EMP, Your Honor. It's EMP high level is what this was Ms. Bauhaus's contention. So stop calling it house arrest. It's EMP house arrest. So if we're gonna, I say that somewhat jokingly, Your Honor, just if we're going to be reflecting it in the order, I just request that it's be the electronic monitoring program and the federal electronic monitoring program.
Yes, he is released from the state electronic monitoring program as long as he stays on the federal electronic monitoring program under the exact same conditions that they are under now. If anything changes, he has to report to the state of Nevada within 24 hours to be replaced on electronic monitoring program.
Thank you very much, Your Honor.
All right, thank you both very much for all your work.
Your Honor, just as one more point of clarification, the court is not modifying any other release conditions, correct?
No, bail stays the same, everything else stays the same.
Yep, understood. Thank you, Your Honor.
Thank you very much, Your Honor.
Okay, so it's going to be a pretty long video. It's 32 minutes. So go to Fake News Network and check out the whole video. Now, in this circumstances, the judge actually did the right thing. Because the two jurisdictions had conflict, and it was only a matter of time before it failed and collapsed onto the one guy. Okay, I still don't believe in this monitor system and all that kind of stuff. I don't believe anybody should be sitting in jail waiting for court because there's no due process. The due process is to be convicted, not sitting in jail waiting for a court date. They've already been convicted without even court. And you may get down to this brass tacks or probable cause, this, that, here, and there. Well, yeah, that's fine and dandy, probable cause. But that's not due process. And I'll go back into what we need to start actually challenging is like when you get pulled over, get arrested or anything, is to automatically say 3 times. Never less than 3 times. Do as much as you have to, but no less than 3 times. I want to go directly to the magistrate. Directly to him. Not to go get booked in, because once you get booked in, you are arrested, y'all, of maybe a crime. You have never been convicted. But you're technically, when you get all clocked in and you're in jail and all that, you're convicted. You just haven't had the judge say you're convicted. And then when you go in there and fight, and if by chance you win the case, well, as damage is done, you've been convicted by the cops. Alright? And we're going back in again. We've been so dumbed down. This 48 hours, 72 hours was for traveling judges back in the old days, for them to travel to actually, for the people to actually see a judge. We got judges 24 hours a day now. Alright? And we got phone calls, monitors, and all that. By gosh, a cop pulls you over and says, this. Unless there's a particular warrant, whatever crime, especially with the auditors and cop watchers out there, as soon as they say they're going to arrest you, demand 3 times of going to see a magistrate right then and there. At least you know that it's been recorded and on file. Okay? And there has been case law saying that you have the right to go see the magistrate. That's because that's technically due process. And if you get booked in and all that, and you're sitting in jail, that is not due process. You have been judged, sentenced, period, by the cops. And the cops do not have that authority. They bypass the authority, and we're under the illusion of such thing. Just saying. Again, this is my opinion. I am not giving legal advice. However, I don't look straight forward. I always look around me to be able to protect myself by any means necessary. And I suggest you guys maybe start looking up some case laws, so that way you can have facts to back you up, and maybe actually start carrying it in your pocket. And that way, next day or two, you can, when you do happen to see the magistrate, look, this right here says I had the right to see you last night. Well, I'm not going to wake up the cop 3 o'clock in the morning. Well, I guess you're a wrongdoer, and you're going to be held fully responsible as a man or a woman. Because now you convicted me of a crime that may or may not have been done. But that's the judge's responsibility, not the officers. So I suggest you wake up that judge 3 o'clock in the morning and tell him to get his butt up and meet you at the courthouse, so we can have due process served correctly. Just saying, it's my opinion. Once you say it 3 times, and dare I say it, officers cannot give legal advice. Challenge their jurisdiction, right? Do you have jurisdiction in this matter? Well, yes, I do. You busted him. He just gave legal advice, buddy. He is in deep poo-poo right now. And anytime you go into a traffic court, you ask that question. That district attorney, oh, no, he can't do that. He can't do that. Why? because he's given legal advice. He's given an answer that he has no knowledge of. He's, by hearsay, he thinks he has jurisdiction. But you challenge that officer up on that jury stand on that traffic ticket. Yes, sir. Do you have jurisdiction in this matter? And that prosecutor's going, no, he can't answer that. That's a legal advice. But if that attorney don't catch it, and he answers it, ask for this to be dismissed because Officer Jess actually gave legal advice, Your Honor. Well, shit. It's up to the judge then. Then you go after the judge and says, well, I'm going to allow it. Oh, okay. Thank you. All right. This will be the People News. Bye, y'all.